Hello everyone. In this session, we are going to discuss research methodology module 5. In module 5, we will be discussing industrial design, eligibility criteria, acts and laws to govern industrial design. Myself Sharath, without a further ado, let's get into the video. So, first we'll discuss what is industrial design. The word design is defined as the features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article. The design may be of any dimension. It may be of one dimension, it may be of two, or it may be of three dimensional, or the combination of all these. The word design is defined as a feature of shape. It can be a shape. The design which we are creating is can be of a shape. It can be a configuration. It can be pattern. It can be ornament or composition of lines and colors. It may be anything. In addition, it may be created by an industrial process or means, whether can be manually created or it can be mechanically or chemically composed, can be separately created either any mechanical or any manual or only a chemical, or can be combined or it can be combination of all these. But the word design does not include any mode or principle of construction or anything which is substance, merely a mechanical device. The main objective of registration of industrial design is to protect and incentivize the original creativity of the originator and encourage others to work towards the art of creativity. What is the main object? The main object is to protect the design and incentivize the original originator. So now we'll discuss what is the key aspects of industrial design. The first key aspect is aesthetic considerations. What does aesthetic consideration means? Industrial designers focus on visual appearance of a product to ensure it is appealing and engaging for the user. So aesthetic consideration means it should be visually appealing and it should engage the end user. The second one is functionality. What does functionality means? Products must be functional and user friendly. It should be user friendly and it should meet the expectation of the user. It is the main thing. It should meet the expectation of users. The third is ergonomics. What does ergonomics means? Ensuring that products are comfortable and safe to use in a crucial aspects of industrial design. Ergonomic is nothing but the design which we create must be comfortable and it should be safe to use for the end user. Now, materials and manufacturing. Designers must consider the materials, uses, and manufacturing process to ensure products can be produced efficiently and sustainably. Here, sustainability and efficiency matters a lot. The manufacturing processes of the design must ensure the products can be efficient and sustainable. It should the materials used should matters a lot. The fifth is innovation. Industrial design often involves developing new products or improving existing ones through innovative solution. Innovation is nothing but creating the new things which is not existed or improve the existing ones. The design must be of unique. Now eligibility criteria. We'll see what are the eligibility criteria to apply for an applicant for industrial design. For a design to be eligible for protection, it must meet certain criteria. So we will see what are these criteria. These criteria are typically outlined in national intellectual property laws, such as Design Act 2000. The main Design Act was formed in India was in the year 2000. So what are the eligibility criteria? Novelty. The design must be new and original. How the design should be? It should be new and it should be original. It cannot be identical to any previous design published in or used. It should not be identical which is already existing. It should be a new one, whether it was registered or unregistered. No matter what it was registered or unregistered, it should be a new one. The design must not have been made public before filing date. Before the filing date, no one should publicly made available the design which the designer is design. So we'll see an example now. A new car model with an innovative and unique body shape never seen before in an existing model can be eligible for protection. See, a new a car model is launched. So how it should be? It should be of a unique body shape and it should never been seen before. The existing model and it must then it will be eligible for protection. So the car which we design should be innovative and it should be have unique shape and feature than any existing model. Now we'll see originality. The design must reflect originality and creativity, which means that it should not be simple reproduction or a modification of existing design. It should be unique. It should not be a reproduction or it should not be a modification of an existing design. For example, a chair design with completely new structural configuration of its legs and backrest can qualify as original. If a chair which we designed has completely different structural configuration and it has completely different backrest which can qualify as original. It should have no similar design of existing design. Non-obviousness. What does non-obviousness means? The design should not be obvious to someone skilled in the art. This means that the design must offer a level of creativity that is not immediately apparent to the other in the field. If example, consider I'm a designer. So I designed a chair. Consider I designed a chair. The design must be a new design. If any other designer sees the design of what I created, it should not be apparent. It should not be any design of a level creative, just not be immediately apparent. It should be of a unique way. Let's say an example. A smartphone case that integrates a unique ergonomic shape with its visual appearance may be considered non-obvious compared to a standard phone case. A phone case, if I design a phone case, it should be of a unique shape, ergonomic shape. It should be visually appearance. It should not be non-obvious to compare with the standard phone case. No visual appeal. The design must primarily be a visual creation, cannot be based on functional or technical features, though product's visual form often ties with its functionality. It means the functionalities of some designs cannot be changed. Only the technical features or the aspects of the technical features can be changed. So we'll see an example what does it means. The aesthetics of a kitchen blender, such as its shape, texture, and color scheme, would qualify, while its motor speed and control mechanism would not. If we take a kitchen blender, the motor speed and the mechanism of the motor will not be changed. Only we can change its shape or the texture or the color scheme of the blender to make it a unique product. Now we'll see industrial application. What are the industrial applications? The design must be applicable to industrial mass production. This requirement ensures that the design can be produced on a large scale factories. The design which we are creating should be available for mass production. For example, the design of a new visually appealing lamp that can be reproduced through industrial process such as molding or stamping would meet this criteria. So if a lamp is designed, it should meet the product, it should meet the user requirements. If a user wants more lamp, it should be available, produce more lamps. Now we'll see the new topic, acts and laws to govern industrial design. What are all the acts? As I said before, the Design Act was implemented in the year 2000. In India, industrial designs are governed under the Designs Act 2000 and Design Rule of 2001. These 2000 Act and 2001 Design Rule are amended many times in the year 2008, 13, 14 and 19 followed respectively. The Design Act of 2000. This law governs the registration of industrial design in India. It governs the registration of industrial design in India. It provides for the protection of the visual and aesthetic aspects of the products and prevents unauthorized replication or imitation of the design. What does this law do? It provides the protection of the aesthetics of the products to prevent unauthorized it may be replication or it may be infringement of the design These are all prevented by the Design Act of 2000. So we will see what are the key features of the Design Act 2000 in India. So registration. Designers can apply for registration, obtain exclusive rights over the design. Only the designer has the exclusive right of the design. No other unauthorized is accepted. Term of protection. The protection lasts for 10 years and we can extend it for another 5 years, which makes a total of 15 years. Next is infringements. Any unauthorized use of a registered design can result in a legal action. What does infringement means? And any unauthorized access of the design which is already registered without the permission is known as infringement. We'll see an example. If a designer creates a new fashion dress with unique embellishments and applies for registration, no one else can replicate this design for a commercial purpose. Consider if a designer designed a new fashion dress with a unique features, he is already registered and patented all those features. No one else can replicate this design without his permission or without his consent. Now we'll see Hague Agreement. It is an international agreement. Now the latest we discussed only Indian Act. Now we are seeing the international agreement. This international agreement, the Hague Agreement, administered by World Intellectual Property Organization, shortly we'll say it as WIPO. The Hague Agreement allows designers to register industrial designs in multiple countries through a single international application. The countries which are registered under the WIPO are accepting all the designs and all the registered with a single international application. This is the single international application. What are the key features? Simplified registration. Designers can file multiple countries as the name suggests. It is simple to register. He can access global protection. It provides global protection for industrial designs across the member countries of the agreement. The countries which comes under WIPO agreement, they are responsible for the protection of the design. For example, a designer based in US who wants to protect a new furniture design in both Europe and Japan can file single application under the Hague Agreement. So, if a designer based in US who wants to protect his furniture design in Europe and as well as in Japan, he can apply for a single application under the Hague Agreement to protect the design of the furniture. So now we'll see European Union Design EC number 6 bar 2002. This regulation provides a framework for registering and protecting industrial design across EU member states in the sense European member states. This act is applicable only for European countries. Key features. Registered Community Design RCD. A design can be registered as a community design to secure protection in all EU countries. Unregistered community design. This provides automatic protection for designs that are new and have been disclosed to public in Europe. Only the European members can access these design which are registered under RCD. For example, a new sneaker design can be protected all across Europe countries if registered under RCD system. If a new sneaker brand is registered in Europe under RCD, then it can be accessed all over all the European countries can access this sneaker design. United States Design Patent Law. In the US, a design patent is issued for new and original designs of articles of manufacture. The protection is given for 15 years. This is a time period over 15 years is the date from the patent grant of the patent. This United States design patent law is applicable for US based countries. Key features. Design patents. These protect an ornamental design of a functional item but not its functional aspect. Term of protection. As we seen, it is last up to 15 years and infringement can lead to legal consequences. No infringement must be done if it is registered under any of the law. For example, a manufacturer of a new bicycle helmet design can apply for design patent to protect its unique shape and appearance. If a manufacturer is manufactured a design for the helmet, If he has registered, he can file a complaint for the unauthorized access of the same design of the helmet which the manufacturer is already registered. Next, we'll see some of the famous industrial design, like Coca-Cola bottle. Everyone has heard about Coca-Cola bottle. The contoured shape glass bottle of the Coca-Cola company is marveled as a master showpiece in the field of industrial design. It was designed in the year 1915 and it is still a synchronous for all eyes. This Coca-Cola bottle has a unique shape and its design was patented in the year 1915. From 1915, the ownership is owned by the Coca-Cola bottle. No other company or no individual or no organization can rep- uh, reproduce the shape of the Coca-Cola bottle without the consent or without the permission of the company Coca-Cola, or else they'll face the consequences. We'll see iPhone. iPhone, it is a highly popular mobile phone manufactured by American company called Apple Incorporation. The sleek, handy, and rectangular body is pleasing to the eyes. The corners are round and smooth. The features such as on and off speech volume are easy operate. The iPhone mobile has its own shape and sleek, and it is a popular and a premium looking phone. It cannot be copied as the design is owned by the Apple Incorporate, and only the Incorporate of Apple can exclusively use the rights for the design and the applications of the iPhone, and no other individual or an organization can use it without the consent or the permission of Apple Incorporation. It is a US based company. So, as of now, we discussed what are the uh, industrial design and what are the acts and laws. We see international laws, American law, European law, and Indian Design Act of 2000. And we had seen the eligibility criteria of what are the design. So this is it for today's session. Thank you.